bearing in mind this unfolds against the backdrop of United Nations Subcommittee for the Prevention of Torture inspectors being denied access to various New South Wales correction facilities. We're going to be looking at the case of State of New South Wales versus Kiskinen, preliminary, 2021, NSWSC 915, Justice Julia Lonergan. And I'm going to be looking at particularly the treatment that the defendant, Juha Kiskonen, received, and particularly the mental health review tribunal and the psychiatrist involved, and what international conventions they've broken in the process. And we'll have a look, some of these things. And we'll have a look at some of the supposed delusions that Juha's suffering from in terms of how he'd been diagnosed, how he'd been treated, and we'll look at the sheer terror of the situation when the ignorance of those psychiatrists treating have real horrific outcomes for the prisoner in question. All of that to say nothing about the spurious grounds on which he was detained in the first place. Yeah, and in a subsequent video, I'll focus on the behaviour of the Fixated Persons Unit of the New South Wales Police Force, in particular Detective Senior Constable Matthew Reason. That is what got Juha Kiskonen in this unfortunate situation in the first place. But before I start digging into this, I thought it'd be good just to hear a little bit from Juha himself. We can familiarise ourselves with him.
But look, since I've had so many people ask me, I will address the video. And one of the first things that Wayne actually said was that Stephen refers to most people as lunatics. Well, yeah, he does, but more so retarded, because we all have been retarded by the education system in this country, because the Occupy has controlled it since 1931. Then you say that Stephen has proclaimed himself as the king. Well, Wayne, that's completely wrong. I'd even go as far to say it's a flat-out lie. And he certainly hasn't demanded anybody or even asked that anybody worship him, because you don't worship anybody. And you call it a deluded rant. Well, if facts are deluded, then yeah, maybe it is a deluded rant, a factual deluded rant. But Wayne, look, if you think that he said something wrong, why don't you actually pinpoint something that he said is wrong and show how it's wrong, if you can. Look, I'd expect you to say that Stephen's wrong, because you've made an oath to the foreign occupier in this country. You work for the enemy. You are in allegiance with the enemy, so I wouldn't expect any less from you. Then you say that he talks about a realm of the Anzac. Well, yeah, it's not entirely correct there, Wayne. He talks about a kingdom of Australia that was that came about because of the actions and sacrifice of the Anzac. But the fact that you say that there's no such thing, well, clearly you're wrong again, or you're lying, or both. Now there's a foundation stone at the Shrine of Remembrance that was laid for a kingdom. There's quite a bit of symbology that goes towards that. But, don't take my word for it. You can read Stephen's papers. He lays it all out. You can read the Treaty of Versailles. You can read the Hague. You can read all of the things that Stephen points out, and you'll see that he's correct. But also, you're very confused there, Wayne. You talk about Canberra, and I think you're trying to say that Stephen has said that there's a shrine there. Well, no, there's not. There's a memorial there, and there's the grave of the unknown soldier there as well. And the fact that you are so disrespectful to the dead, I don't think you're a very nice man, Wayne. But the shrine is in Melbourne, and nobody's ever said any different. It's you that can't get your facts together, and you can't quote people correctly. And then you talk about 1919. Yes, very, very special year for us, Wayne. And you say that Billy Hughes had no authority. Well, he was given that authority by the King of England, so that Billy Hughes could represent us at the Treaty of Versailles, at the signing of the treaty, instead of the King of England. And this act actually gave us our sovereignty, Wayne. And the reason that Billy Hughes was allowed to do that was because that was the plan, to give us our sovereignty from England. But you clearly don't like that, do you, Wayne? Because you made an oath to the Queen of Australia, Queen Elizabeth II. And you've got to protect that, don't you? You've got to protect your Queen. So this is why you're dead set against it. This is why you don't want everybody to know that we're sovereign and independent from England, because then that would show you to be the real lack of a man that you are, the traitor. And you can also read the Statute of Westminster, 1931, and it tells you straight out that we're sovereign. All brought about because of Billy Hughes signing that treaty on behalf of this country instead of the King of England, showing the world that we can stand on our own 2 feet. And this, of course, is backed up by Lord Balfour and his letters and the Imperial Conferences of 1926, where they discussed the Kingdom of Australia and its sovereignty and the fact that we didn't have a head of state, and which also led to the crowning of King George V as the King of Australia in 1927 in Melbourne. And then you say that the Constitution is the supreme law of the land. Well, no, it's not, Wayne. The Bible is. The Bible comes before the Constitution. I mean, if you read the Constitution, it tells you under the blessing of Almighty God. And then you brought up the White Papers. Well, the White Papers wasn't thrown in the bin because they were rubbish. What they actually did was they shut down the Attorney General and Governor General because those papers are correct. And if they weren't correct, and if Stephen wasn't correct, and after everything he's said about the Australian government, and the Attorney General and the Queen and the Governor General, don't you think they would have come after him for sedition by now? Locked him up if he was wrong for all the things that he said about them, all the things that I've said about them. Don't you think they would have come after me as well?
So to begin with, we've got the decision that the amended summons for the extended supervision order is dismissed by Justice Julia Lonergan. And secondly, plaintiff to pay the defendant's costs. So next in the New South Wales Supreme Court document, we'll look at item 20. These activities led to the arrest of the defendant at his home on the 30th of July 2020, where he was charged with 2 counts of used carriage service to menace, harass and or offend, and with firearm offences related to a gel blaster pistol found at his home. So it's also worth noting from item 12 that in the Justice's words, the UKOA, United Kingdom of Australia, has not been specified in the regulations as a terrorist organisation. So this is a problem that the plaintiff, being the state of New South Wales, represented by the police prosecutor, continue to come up against as they try to paint the defendant as a terrorism act offender. But the organisation is not a terrorist organisation. So we move now to item 33 in this document. Observations regarding the defendant's mental health and the basis of the Community Treatment Order, CTO. 33. The defendant was referred to the Mental Health Review Tribunal, MHRT, shortly after his arrival in custody. In a report of 8 September 2020, the Psychiatry Registrar from Justice Health stated that the defendant had been referred to the Mental Health Screening Unit in the context of, quote, a deteriorating mental state, end quote. 34. On 10 August 2020, the defendant was reviewed by staff specialist psychiatrist Dr. Keating. She was asked to see him in the context of a recent hunger strike and to examine whether he was psychotic. She noted the following. So before I read on, it's just worth noting here that this was the 10th of August 2020. So the defendant has only been in custody for 10, 11 days at this point. And already they are putting him in front of the mental health team being reviewed by a psychiatrist. And it's also worth noting here, before I go back to 34, the 36, these are the Justice's words. Returning to the September 2020 report for the MHRT, the registrar recorded that the defendant did not have a history of mental illness prior to custody, but that he had a, quote, systematized paranoid delusion that there was unlawful military occupation of Australia, end quote, and that there are, quote, two constitutions of Australia, end quote. And due to these beliefs, he believes that police officers should be, quote, hung for war crimes, end quote. He also had, quote, grandiose delusions that he is the mayor of Campbelltown and had been putting flags around the suburb, end quote. He described the defendant as being, quote, very guarded, end quote, about the psychotic beliefs, and that he refused to engage with the treating team. He apparently had repeatedly told nurses he was, quote, going to be released within days, end quote, and, quote, has friends in very high places, end quote. The registrar concluded that he was insightless into his persecutory delusions and was a high risk of harm to others if his beliefs are challenged. At that time, he continued to refuse psychiatric medication. The registrar concluded that the risk to others was due to his untreated mental illness. So he was transferred to Long Bay Hospital for involuntary treatment. It's just noting that the registrar recorded that the defendant did not have a history of mental illness prior to custody. But within 10, 11 days, they begin putting him up in front of the psychiatrist and commence involuntary treatment. So, back to 34. On the 10th of August, The defendant was reviewed by staff specialist psychiatrist Dr. Keating. She was asked to see him in the context of a recent hunger strike and to examine whether he was psychotic. She noted the following: went into long, detailed conspiracy theories which made it difficult to elicit other history. Very fixated and preoccupied by these ideas. For example, I'm of a different jurisdiction. You only have to research international law and read the Hague. That treaty specifically deals with military occupation of this country and is under illegal military occupation by the United Nations. I was going to expose it, so now I'm being victimized. So here we go on the International Committee of the Red Cross website. I can find Hague IV, Convention respecting the laws and customs of war on land, and its annex regulations concerning the laws and customs of war on land from The Hague, 18th October 1907. So we go through that. We can read every article there. So yes, the Hague treaty does specifically deal with military occupation of his country. So the defendant is not delusional there. Continuing from item 34, this is Dr. Keating, or this is Justice Julia Lonergan quoting staff specialist psychiatrist Dr. Keating, quoting the defendant, "They, police, mocked me because of what I know. The government, which is the United Nations, and also the police service the Roman crown. It doesn't belong in this country. It's actually unlawful under the Act of Supremacy 1688. I asked what the Act of Supremacy is and said I've never heard of it. They don't want you to know it." This is the defendant. Quote, "They don't want you to know it. That's why. There are two different constitutions in this country. One that puts people over the government, the other puts the government over the people. They don't want people to know their true lineage, their true crown, the imperial crown." So here we are from the Bill of Rights, 1688. Whereas the Lords spiritual and temporal and commons assembled at Westminster lawfully, fully and freely representing the estates of the people of this realm, did upon the 13th day of February in the year of our Lord, 1688, present unto their majesties, then called and known by the names and style of William and Mary, Prince and Princess of Orange, being present in their proper persons, a certain declaration in writing, made by the said Lords and Commons, in the words following this. The heads of Declaration of Lords and Commons recited: dispensing, suspending power, committing prelates, ecclesiastical commission, levying money, standing army. And when we look further down here, we will find new oaths of allegiance. And allegiance, I, A.B., do solemnly, sincerely promise and swear that I will be faithful and bear true allegiance to their Majesties King William and Queen Mary. So help me God. Supremacy. I, A.B., do swear that I do from my heart abhor, detest, and abjure as impious and heretical this damnable doctrine and position, that princes excommunicated or deprived by the Pope or any authority of the See of Rome may be deposed or murdered by their subjects, or any other whatsoever. And I do declare that no foreign prince, person, prelate, state, or potentate hath or ought to have any jurisdiction, power, superiority, preeminence, or authority ecclesiastical or spiritual within this realm, so help me God. And we can see if I look at crown images, you see an imperial crown, Australian Commonwealth Military Forces. We see the Australian Army. So maybe I'm deluded, but I see a Roman crown. And I see an imperial crown. But this might just be my delusion speaking. Once again, we see a Roman crown. Roman crown. Imperial crown. There are a great many more examples of this. So the psychiatrist here doesn't know what the defendant's talking about. She says, I asked what the act of supremacy is and said I've never heard of it. But she still goes on to be coming up with a diagnosis as to the mental health of the defendant. So back to item 34, this review from psychiatrist Dr. Keating, quoting the defendant. All started when I found out the fact that the Australian government isn't who they say they are 6 years ago. I took my neighbour to court, which I did myself because I like to do things myself, then started researching the law. That's when I started to realise it all. Found it to be 100% irrefutable and correct. They want to shut me up. When I wasn't so popular on Facebook and YouTube, they didn't care. But now that my message is getting out there, they're getting worried about me. Reports more than 5,000 followers on Facebook. Quote, but I'm working with other people that are targeted as well, end quote. And later in the interview, quote, RE charges using a carriage service. I sent an email to a detective, James Gaddard, I think that's a typo, it should be Gatwood, of the Fixated Persons Unit after he mocked me and mocked the information which I shared with him, which is irrefutable. If he's going to mess with the loyal people of this country, he will probably hang. Firearms offence for a, quote, gel blaster, end quote, like a paintball gun, quote, not illegal in other states, end quote, denies intent to use it to harm others. Quote, they offered me legal aid, but I can't use them. If you read the lawyer's handbook, you will read that all lawyers' first duty is to the court. So how can you trust them? End quote. Item 35. Dr. Keating concluded her report as follows. 50-year-old man with minimal psychiatric history presents with escalating delusional ideation over several years, accompanied by some grandiosity. No other clear symptoms of psychosis or major mood disorder. Note, history of bowel CA with possible signs of recurrence 2 years ago. Need to exclude organic cause of current presentation. Has acted on his delusional beliefs by making threats and disobeying legal directives under the belief they don't apply to him, which has caused harm in various domains in his life, particularly his relationships and his reputation, now leading to legal sanctions. Recent risk to self via hunger strike, however now eating and drinking. So my question is this: how can you, as a psychiatrist, proceed to diagnose a delusional ideation or grandiosity, psychosis in someone if you yourself do not understand, have not researched the information presented to you by the patient? Bearing in mind more so that this is 10 days of him in custody with, as we see down here in 36, the registrar recorded that the defendant did not have a history of mental illness prior to custody, but that he had a systematized paranoid delusion that there was unlawful military occupation of Australia, that there are two constitutions of Australia. And due to those beliefs, he believes the police officers should be hung for war crimes. So here we have the Commonwealth of Australia Constitution Act 1900 from legislation.gov.uk. An act to constitute the Commonwealth of Australia. Whereas the people of New South Wales, Victoria, South Australia, Queensland and Tasmania, humbly relying on the blessing of Almighty God, have agreed to unite in one indissoluble federal commonwealth under the crown of the United Kingdom of Great Britain and Ireland, and under the Constitution hereby established. And whereas it is expedient to provide for the admission into the Commonwealth of other Australasian colonies and possessions of the Queen, be it therefore enacted by the Queen's most excellent Majesty, by and with the advice and consent of the Lords Spiritual and Temporal and Commons, in this present Parliament assembled, and by the authority of the same, as follows. And when I look at the Commonwealth of Australia Constitution Act on the Australian Government, legislation.gov.au, we see it begins again the same way. Whereas the people of New South Wales, etc., under the crown of the United Kingdom of Great Britain and Ireland, and under the Constitution hereby established. So, is there not a question here that remains unanswered, whereby we have the Constitution of Australia coming after the blessing of Almighty God, and the crown of the United Kingdom of Great Britain and Ireland, which resembled this imperial crown, but no such crown is present in the current Parliament in Australia. We have supposedly a line of authority to this crown. So are there not two crowns? Are there not two constitutions? This is, if we're sincere, these are questions, and cannot be labeling somebody as delusional for coming to, after actually looking at the questions, coming to a different opinion. So returning to item 36 in the Supreme Court document. After the registrar recorded that the defendant did not have a history of mental illness prior to custody, The registrar concluded that the risk to others was due to his untreated mental illness, and so he was transferred to Long Bay Hospital for involuntary treatment. 37. Documents from the Mental Health Review Tribunal in early September 2020 noted the grandiose delusions against a background of systematized paranoid delusions. The MHRT agreed with the need for enforced treatment. So this is despite the fact that no one has addressed the questions held by the defendant at law. They've proceeded to move to enforced treatment without addressing any of the questions of law. If we look at Rule 90, torture and cruel, inhuman or degrading treatment, this is under international humanitarian law. Rule 90, torture, cruel or inhuman treatment and outrages upon personal dignity, in particular humiliating and degrading treatment, are prohibited. State practice establishes this rule as a norm of customary international law applicable in both international and non-international armed conflicts. The prohibition of torture was already recognized in the Lieber Code. The Charter of International Military Tribunal at Nuremberg concluded ill treatment of civilians and prisoners of war as a war crime. Common Article 3 of the Geneva Conventions prohibits cruel treatment and torture and outrages upon personal dignity, in particular humiliating and degrading treatment of civilians and persons hors de combat. Torture and cruel treatment are also prohibited by specific provisions of the 4 Geneva Conventions. In addition, torture or inhuman treatment and willfully causing great suffering or serious injury to body or health constitute grave breaches of the Geneva Conventions and are war crimes under the Statute of the International Criminal Court. And Rule 92 from the International Humanitarian Law Database, mutilation and medical, scientific or biological experiments. Rule 92, mutilation, medical or scientific experiments or any other medical procedure not indicated by the state of health of the person concerned and not consistent with generally accepted medical standards are prohibited. So what does that have to do with the treatment of Juha Kiskonen, not previously subject to any mental health treatment or diagnosis, but after 10, 11 days in custody, he is subjected to forced medical treatment, involuntary medication. The prohibition of mutilation was already recognized in the Lieber Code. Common Article 3 of the Geneva Conventions prohibits mutilation of civilians and persons hors de combat. Mutilation is also prohibited by specific provisions of the 3rd and 4th Geneva Conventions. In addition, the prohibition of mutilation is recognized as a fundamental guarantee for civilians and persons hors de combat by additional protocols 1 and 2. Mutilation constitutes a war crime in both international and non-international armed conflicts under the Statute of the International Criminal Court. So if we look again at item 36 in the Supreme Court document, the registrar concluded that he was insightless into his persecutory delusions and was a high risk of harm to others if his beliefs are challenged. At that time, he continued to refuse psychiatric medication. The registrar concluded that the risk to others was due to his untreated mental illness, and so he was transferred to Long Bay Hospital for involuntary treatment. This risk to others has not been established, as far as I can tell. And in terms of his persecutory delusions, well, by placing him into the Long Bay Hospital for involuntary treatment for a mental illness that didn't exist before he was in custody just a couple of weeks ago, and then you are forcing involuntary treatment on him, are you not creating persecutory delusions? In that you're breaking the international humanitarian law, Rule 90, torture and cruel, inhuman, or degrading treatment, as well as Rule 92, mutilation in medical, scientific, or biological experiments. So back to the Supreme Court document, item 38. A more detailed report of Dr. Kanzu, Registrar in Forensic Psychiatry, dated 19 October 2020, was prepared for a later hearing at the Mental Health Review Tribunal. This included detail that the defendant, despite denying he had any admission to psychiatric hospital or having ever been prescribed psychiatric medications before, had been admitted to Waratah House in September 2015 following an overdose, although at that point there was, it seems, from the discharge summary, no sign of a mood disorder or psychotic disorder at the time. So why is the plaintiff, the state of New South Wales, bringing this into evidence? He'd been admitted to Waratah House in September 2015 following an overdose, although at that point there was, it seems, from the discharge summary, no sign of a mood disorder or psychotic disorder at the time. So all I see is, once again, trying to paint the defendant with a mental illness that didn't exist weeks before they start bringing it up once he's in custody. Item 39. Dr. Kanzu's report made reference to information obtained from the defendant's de facto partner that the defendant had become increasingly preoccupied with online conspiracy theories, withdrawing from his family and becoming more grandiose and unable to be challenged. And when he was challenged, he would become verbally but not physically aggressive. The de facto partner also outlined certain behaviours on the part of the defendant that Dr. Kanzu thought may be features consistent with a narcissistic personality disorder. Once again, what is the nature of the lens that we're examining the defendant through? This is an item just relying on the report from a conversation that someone has had with the defendant's partner and just taking a quote from that, smearing with the label of conspiracy theories, not physically aggressive. And it may be features consistent with a narcissistic personality disorder. So once again, it's saying nothing. It's just smearing with this label they're trying to put on him of having a mental illness so that they can enforce treatment. Item 40. It was noted that the defendant had been on a hunger strike when he was first incarcerated due to his systematized delusional beliefs, believing he was a prisoner of war unfairly imprisoned. It was noted that he possessed poor insight into his condition and had not been consenting to his medication in the beginning, but was at that time reluctantly compliant with treatment. So again, we're talking about supposed systematized delusional beliefs, though we are not refuting, based on fact, the beliefs held by the defendant, or linking what the threat is posed by the defendant. Believing he was a prisoner of war unfairly imprisoned, this is self-fulfilling the way I see it, because he's being forced treatment on for a mental illness that has not been established, as far as I can tell, for a mental illness that wasn't established or treated before he was in custody. And then the state of New South Wales is violating international conventions on the treatment of prisoners. Where is the delusion? If the psychiatrist assessing the defendant, or the patient, as they might have it, is doing the assessing, and they are ignorant of facts, would they not ascribe delusion where it is simply a lack of information on their part, and they can't see that what the defendant is saying about the Hague Conventions, the Geneva Conventions, international humanitarian law, is indeed at play. He is indeed a prisoner of war, unfairly imprisoned. And they are breaking these conventions by forcing medical procedures with no scientific, no health backing, no firm diagnosis. So I'll move to 42 in the Supreme Court document. The opinion and recommendation concluding the report stated that the defendant, quote, is suffering from delusional disorder, perhaps late onset schizophrenia, but possibly with an organic disorder, a mental illness characterized by persecutory, grandiose, and bizarre delusional beliefs. The mental illness is being complicated by poor insight and poor compliance. With medication, Mr. Kiskonen had shown significant improvement in his mental state. He has poor insight and a history of non-compliance with his medications, means he is at risk of relapse. The treatment team requested the tribunal to grant him an FCTO before release. Mr. Kiskonen will continue to benefit from his antipsychotic medication and further investigation of his medical condition. He will also benefit from ongoing psychoeducation. End quote. This is the opinion and recommendation. Is this law? This is the opinion of a psychiatrist that has real implications for the treatment of the defendant. But they're basing their appraisal on incomplete knowledge, a complete lack of having even investigated the claims from the defendant that they label as persecutory, grandiose, and bizarre delusional beliefs. They have not investigated them, but they prescribe treatment, medical treatment, and he will also benefit from ongoing psychoeducation. But he doesn't appear to be the one that needs educating. He's trying to educate those around him and getting nowhere. So just a quick recap. The defendant was taken for mental health treatment only 11 days into a 12-month sentence for 2 counts of using carriage service to menace or harass, and 2 counts for firearms offences for a gel blaster, a toy, legal in all other states apart from New South Wales. So he made videos that offended certain people, and he possessed a toy that was technically deemed a firearm under New South Wales law at the time. 10 days into his sentence for those crimes, he's placed under the care and under the jurisdiction of the Mental Health Review Tribunal. So he's in a mental health hospital for a mental illness that I'm not getting a clear picture of. Mental illness that didn't exist before he was incarcerated. But they forced medication. So now we get to 43. The report of the MHRT, dated the 5th of November 2020, relied upon the treating report and concluded that it was satisfied that the defendant continued to suffer from mental illness and required further inpatient treatment at the Long Bay Hospital. A further review was scheduled, at which time a Forensic Community Treatment Order, FCTO, would be discussed. It was noted that the defendant said that he would not take any medication which would, quote, change his metabolic state, end quote. But he did not explain what that meant. At that time, the MHRT noted that the defendant was taking olanzapine, which had recently been increased to 7.5 milligrams per day, and which was at that stage being administered by injection. 44. On review on 23rd December 2020 by Dr. Sharma, staff specialist psychiatrist, the defendant said that he no longer believed the things he had previously stated about the government not being legitimate and Stephen being the King of Australia. Dr. Sharma recorded as her, quote, impression, end quote, that, quote, he no longer holds his prior delusional beliefs with the same intensity, but it is not certain that he has become well enough to simply disguise his underlying beliefs, end quote. So once again, we have the labeling of delusional beliefs. But this is all based on the impression, quote, impression, end quote, that he's no longer holding his prior delusional beliefs with the same intensity. But it's not certain that he has become well enough to simply disguise his underlying beliefs. And he's being held by these people for making videos which the state felt threatened and possessing a toy gun labeled as a firearm, as a technicality. He's been put under the holding, the authority of the Mental Health Review Tribunal, force medicated, and it's all based on the opinion, the impression of a psychiatrist. 45. In an assessment by treating psychiatrists at Long Bay Hospital in January 2021, prepared for a further MHRT hearing, the treating team noted that it had received registered post from one of the defendant's, quote, followers, end quote, telling them that they must release the defendant as he is being held illegally, and pleading his case to the Commonwealth Minister of Health, Greg Hunt, and that the defendant had said that he had been instructed in his views by, quote, Stephen, the right and truthful king, end quote. So all I'm seeing is further anecdotal evidence with no real significance, and then the opinions of the treating team. Now, it's not even a person, but it's just the psychiatrists at Long Bay Hospital that get to dictate what goes into the body of the defendant. Item 46. The assessment report concluded that overall, the defendant had shown improvement in his mental state, but was still insightless and, quote, only reluctantly, end quote, accepting his medication, and concluded that he was suffering from a, quote, delusional disorder, perhaps late-onset schizophrenia, but possibly with an organic disorder, being a mental illness characterized by persecutory, grandiose, and bizarre delusional beliefs, end quote. It also noted that he had shown significant improvement in his mental state, but there was a risk of relapse, and so the FCTO was requested to be put in place before release into the community. The report also concluded that he will, quote, continue to benefit from his antipsychotic medication and further investigation of his medical condition, as well as ongoing psychoeducation, end quote. So more of the same, really. We don't have a specified mental illness. We've got an opinion based on who knows what from who knows what, who knows who. And once again, the opinion of this report that he'll continue to benefit from antipsychotic medication and further investigation of his medical condition and psychoeducation. But further investigation, how much time do you need to investigate his condition? None of his beliefs have been investigated as to their validity. So if you haven't investigated the beliefs, but you're proceeding from a place where you understand what is true, what is delusional, you can hold almost anybody as having some kind of mental disorder. If somebody believes in the Hinduistic perception of reality, interpretation of reality, and you're a psychiatrist, and let's say that you're a Catholic, you hold those beliefs, could you not then say that any Hindu has a mental illness, has bizarre delusional beliefs, grandiose? Could you not say that for anybody that holds beliefs outside of your own? How can you say that you are the arbiter of what is true and what is delusional, particularly when you cannot pin down what specific mental illness the defendant has, a mental illness that didn't manifest until 10 days after he was incarcerated. But you continue to play around with his medication and instruct his psychoeducation. And moreover, the threat that the defendant poses to society, to the community, was never established. Item 47. In January 2021, a forensic treatment plan was formalised, which included monthly meetings with his psychiatric case manager in the correctional centre, a 6-weekly meeting with his treating psychiatrist, a requirement to accept treatment and medication as prescribed, and to provide regular urine drug screening samples, and to comply with necessary blood tests to provide for metabolic and clozapine level monitoring. So it's just more invasion, basically, and a lack of bodily autonomy, as far as I can see. Item 48. The last review available in the evidence tendered where the defendant was actually interviewed and assessed was 22nd of June 2021 by Chief Medical Officer Dr. Andrew White, who noted, quote, "Today he presents as somewhat dishevelled, but was woken from sleep to see me. He was pleasant and polite and cooperated with the interview. He said that he no longer believes the things about the Australian government or other conspiracies that he previously did. He admits to becoming completely preoccupied with these beliefs, and that they had taken over his life and damaged his relationships. He attributes his change in mental state to the shock of incarceration and his wife ending their relationship, and does not think that the medication has helped in any way. Medication makes him dumbed down and tired, but he feels better on his current regime than he did when he was on more RX. Accepts his diagnosis and was able to label it as delusional disorder, accepts that he was completely overrun by his conspiracy beliefs, and accepts the label of delusional." End quote. So he's been beaten down. This is after 11 months approximately. Force medicated. He's still saying that he's better on less medication. And wouldn't whoever say, if you've been in custody for 11 months, wouldn't you say whatever is going to end the torture? Okay, back to this review by Dr. Andrew White. Denied any ongoing interest in pursuing his conspiracy theories. His plans on release are to go back to work and attempt to reconcile with his wife. Said that family is the most important thing, and he wants to do the right thing by his family. Will continue to take RX because he knows he has to, and police and P&P will require him to take it. Also admitted to smoking THC prior to custody and said that he won't do that anymore because he doesn't want to go back to it, and he is also aware of parole conditions. Plans to go back to live with his ex and kids, boys in their 20s. Says IMP, I'm not sure if that stands for implication or implied. Delusional disorder seems most likely diagnosis, probably on B/G of narcissistic paranoid PD and THC use. So we're still at 11 months in, we're still at a most likely diagnosis. It seems like no other profession gets to play around in terms of diagnosing an issue for as long as these people do, whilst they have complete and utter control over what goes in and comes out of the defendant's body. I noted in item 47, yes, they still requiring to accept treatment and medication as prescribed, and to provide regular urine drug screening samples. He's in your custody, and to comply with necessary blood tests to provide for metabolic and clozapine level monitoring. He's entirely within your custody, and you are putting these things in his body. It is just It's just next level. Control and so it's torture. I don't. Surely this satisfies anyone's definition of torture, mind control. So that basically gets us to the end of the story with the psychiatrist, MHRT. I just wanted to go through now some of the key points where we do actually have evidence of a ruling that might help us to clear up what, in terms of the attitudes, the beliefs held by the defendant, can clearly be stated as the way I see it, is not delusional, or at best, they are still up for debate. So in item 81 here, the Justice Julia Lonergan's noting, this is the defendant's lawyer, Matthew Johnston, speaking, but this is Julia Lonergan's notes of his words, his argument. First, the sentencing magistrate specifically declined to sentence the defendant on the basis that he had an allegiance to a particular group. And we note earlier that this group, the United Kingdom of Australia, has never been labelled as a terrorist group. And I think we find out later on in the document that it could not possibly be one. Okay, back to this is Julia Lonergan quoting Matthew Johnston, the attorney for the defendant. Second, evidence adduced on sentence did not, properly read, lead to a conclusion that he was making a call to arms to his associates to hang police or engage in any act of violence. In fact, there was a number of statements that show an intention to act peacefully and that he expected others to act peacefully. Third, there is no relevant terrorism intelligence. The material in the affidavit of Detective Senior Constable Reason is not a report relating to terrorism or a terrorist organisation. It is full of speculation and opinion without real foundation as to what other unidentified people might do. Emphasis was placed on the concluding paragraph of DSC Reason's affidavit that it should be read as a picture of a group that has effectively dissipated, with members being disillusioned and having moved on to different groups. 87. The court could find that what the defendant is advocating is not conduct in support of violent actions, but rather application of what he believes might be the result of due process of law. And so it is in effect an extreme political view advocating political change as opposed to an extremist view advocating illegal violence. I just wanted to finish up by going through the Justice's final words in this document. Am I satisfied to a high degree of probability that the offender poses an unacceptable risk of committing a serious terrorism offence if not kept under supervision under the order? 122. Seems to me that the requirements of subsection 20A and B of the Act have been met. I entertain some doubt that section 20C has been met, but I consider it just made out on a revisionary and reconstructed analysis, that because of some of the identified past activities of the defendant, with hindsight, he could be viewed as a quote, convicted New South Wales terrorism activity offender, end quote. 123. However, I do not accept that there is a high degree of probability that the defendant poses an unacceptable risk of committing a serious terrorism offence if not kept under supervision under the order. 124. The evidence taken at its highest is equivocal as to where the defendant currently stands regarding his beliefs or otherwise in the doctrines of the UKOA. 125. There are multiple layers of speculation involved in the material upon which the plaintiff relies to reach the proposed conclusion, as to the defendant's relevant risk. 126. I also doubt that the type of activities the defendant might engage in, even if he was still a, quote, believer, end quote, would, properly considered, amount to a, quote, serious terrorism offence, end quote. Fundamentally, however, I dismiss the plaintiff's amended summons because I am not satisfied to the requisite high degree of probability about the risk the defendant poses, and I cannot conclude that he presents an unacceptable risk of committing a serious terrorism offence if not kept under supervision under the proposed ISO or ESO. Orders. 128. I make the following orders. 1. Amended summons dismissed. 2. Plaintiff to pay the defendant's costs. So, I just want to finish with reading that item 126 again, because I think it tells us a lot about where this case stands at law. Quoting Justice Julia Lonergan, 126. Quote, I also doubt that the type of activities the defendant might engage in, even if he was still a, quote, believer, end quote, would, properly considered, amount to a quote, serious terrorism offence, end quote. So I'm just going to add this at the end. This is my opinion. This is what I see. But I suspect that the state very much likes this mental health, psychiatric arm of corrections, because it would appear that they can craft a reality, they can craft treatments to suit their agenda. And there's really no recourse. Certainly not in the moment. We're left looking back and hazarding a guess as to what happened, what was his threat, who felt threatened, and what was the nature of the threat posed. It's all really murky, but it does, to me, appear to be torture. A prisoner of war tortured for his beliefs rather than for having committed any crimes.